So why don't you have custody of your daughter? Let's not say baby mom. Let's not use that term. Let's say the mother of my child.
Mother of my child, she didn't let me.
Well, why doesn't the mother of your child have custody of her child? But in your case, there is something else going on that your daughter would not be placed with her mother, and instead she's being placed with your grandmother.
Welcome to the bench of justice.
All right, the court is calling 2022 CR 6213, State of Texas versus Justin Gonzalez. Can I have parties announced for the record for the state? For the defense?
Kelly Fiddle.
And are you Justin Gonzalez? All right, counsel, I'm going to show you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. All right, everyone in the jury box, when we're on the record, you all need to stop talking. And everybody don't congregate or lauder around Brenna. And state, that's Brenna's private space.
This is not mine. I can move it.
That part is fine. That's
Nope. See, once you give people an inch, sometimes they take a mile.
Judge, I'm gonna put it right here.
So Brenna, when
it's really just right behind me. Don't close me in over here.
I'm closing you in. Brenna, when I say the defense can't do it, the state can't do it either. We are a fair court. All right, Mr. Gonzalez, I'm going to show you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
I believe so, Judge. They're waiving count one, Judge. That sounds right.
All right. Any objection to the waiver of count one?
No. I'm sorry, Judge. I didn't
Oh, no.
do the paperwork on this.
No, I appreciate you standing in. Mr. Gonzalez, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it?
Yes.
And did you sign it in all the appropriate places?
Yes, Your Honor.
You understand the state is proceeding on count two, and count two is an aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision because you're not eligible for community supervision, and sentence you up to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he is currently competent and was legally sane at the time of the offense?
Yes.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Oh, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
Oh, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, state is proceeding on count two, which is an aggravated assault with a deadly weapon. There's a $1,500 fine, affirmative finding of deadly weapon. They're recommending deferred adjudication. This is to run concurrent with the DWI case number 661512. They are taking in consideration County Court Cause number 651279, 651280. There's an affirmative finding of family violence, and there's to be no contact with Roman Ruiz. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense is at the plea bargain agreement?
Yes.
State is at the plea bargain agreement.
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No.
Off the record, can you let Caroline know I'm sending something back to her if she could please print it? Back on the record. Next, I'm showing you outside the plea bargaining agreement. The state is requesting that your community supervision be for a term of 7 years. There'll be a TAP evaluation, 150 hours of community service restitution. You're to follow the recommendations of TAP, mouth evaluation, parenting classes, hostility, aggression course, and UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Off the record. Can we make sure that the interpreter is here because I have an answer to the question? Thank you. All right, we're back on the record. Then to offenses indicted in count 2, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence.
Yes, Your Honor. At this time, state up for state's exhibit number 1 and its attachments.
No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Sure.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. And just let me know when the interpreter arrives. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
No, Judge, just ask you further.
All right, so Mr. Gonzalez, have you ever been diagnosed
No.
with mental health issues?
No.
All right, so why are you pulling the knife on your brother?
There was just an argument. It was an argument.
Well, a lot of people have arguments and they don't pull a knife on anyone. And there wasn't even a dinner at the table. You just pulled a knife.
It's my brother. That's another thing that's worse. And I apologize to him. I already spoke to him.
Well, I mean, it's your brother, so that makes it bad because your mom is probably hoping that her siblings would not attack each other, right?
Yes.
And then what else makes it worse is that your mom is actually taking care of your daughter, which is something you should be doing that you're not doing. So why does your mom have custody of your daughter?
I guess because my
No, it's not, I guess. Everybody knows why they don't have their children. So why don't you have custody of your daughter?
didn't have custody because my baby mama didn't let me have.
Okay, let's not say baby mom. Let's not use that term. Let's say the mother of my child.
Mother of my child. She didn't let me
Well, why doesn't the mother of your child have custody of her child?
because I'm behind on child support.
No. There's a reason why biological parents don't have custody of their children. Sometimes they put them up for adoption. But in your case, there is something else going on that your daughter would not be placed with her mother, and instead she's being placed with your grandmother. So was Child Protective Services involved?
No.
That's either yes or no.
No.
So they want a mouth evaluation, and you're saying you don't have mental health issues?
I don't,
All right, so what's the reason why you don't have custody of your daughter?
because I'm not stable.
All right, and what does that mean, you're not stable?
I don't have my own place yet.
Well, no, I mean, it's more than you not having your own place, because how old is your daughter?
She's 9.
All right, she's 9 years old, and you haven't had custody of her. So it's more than you not having a stable place. So was there drugs involved? What's going on?
No, I just have.
Right, let me explain something to you. You have entered a plea on this case.
Yeah.
You're going to be placed on probation. I have sent people to prison when they didn't follow through on their contract with the court for their probation. I take no pleasure in sending people to prison. When I place people on probation, I'm hoping they're going to be successful. They're going to do everything. They're going to end up going off in the sunset enjoying the rest of their lives, and this is just going to be a bump in the road. But if you're not honest with me, guess what? I'm going to send you into the world like a newborn baby without any protections and any support. So I'm trying to figure out, and I need you to be truthful to me. What are your issues?
I had a drug problem.
And what was the drug of choice?
It was heroin.
All right. There you go. See, that wasn't hard. I always tell people where you are right now in this orange jumpsuit coming over from the jail. This is not where you're going to always be unless you choose that. Okay. So have you ever been employed?
Yes.
All right. What have you been doing?
I'm a truck driver.
All right. Is there any gang affiliation?
No.
All right. Who did your tattoos?
Who did my tattoos?
Yes, which they're beautiful, by the way.
Thank you. Yeah, I did them over in Laredo.
Okay. All right. There's a lot of ink masters would say, as I watch ink masters, the feathers are so great on the headdress.
Thank you.
Okay. All right. So this is what the court is going to do. I'm going to follow your agreement. It's going to be 7 years deferred adjudication. There's a $1,500 fine that will be probated. There's an affirmative finding of a deadly weapon. This will run concurrent with 661512, taking consideration 651279, 651280. And I'm sorry, back with regards to your plea, there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes. Yes,
And
sir.
did you also understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Sure.
All right. And knowing that, do you still wish to continue with this plea agreement? All right. So there's an affirmative finding of family violence. There's to be no contact with Roman Ruiz. So that means no phone call to him or anything. Later that can change, counsel, if things are working out. I'm going to ask for parenting classes, and that'll be triple T. There's 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do that, but if you do, 40 of those hours will be waived. I normally would waive the remaining community service hours for the parenting classes, but in your case, I think you need to stay busy because I'm concerned about the drug addiction that's going on and the lack of responsibility you're taking for that. We're going to do a TAP evaluation. Follow all TAP recommendations. And that TAP evaluation is going to take place while in custody. We're going to go ahead and do a referral to felony drug court. I know that some people will say, he's charged with an aggravated assault, maybe felony drug court won't accept him for that, but they look at it on a case-by-case basis. We're going to do MIOF evaluation while in custody. There's to be hostility, aggression course. There's to be random, well, we're going to do the UA hotline until further notice. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be regular reporting by Zoom or in person. And I'm going to want field visits 2 times per month, random. And the defendant is not allowed to live with his mother. So the location of this incident which is Oak Island, is that correct? All right, the defendant is to have no contact with Oak Island Drive. And defendant is not allowed to reside with his mother And the person who lives at that house, is it just your mother or is it your grandmother too?
No, my brothers live there and my stepdad.
All right. All right, he's not to reside with his mother or his stepfather. Is there anything else that he needs probation? Is there anything that you need from the court in order to be successful? Anything else? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Gonzalez, your mom and stepfather and your brother are taking care of your daughter. That's something that you should be doing, but you didn't step up to the plate, so they did. So you should be making their life easy. And let me explain to you, one of the reasons why I'm not letting you live with your mother and your stepfather, because I don't want any family animosity or confusion because you to have no contact with your brother. So you can let them know that I said that you can't live with them. And
Yes,
it's
Your Honor.
not your brother's fault. You understand?
Yes, Your Honor. And
All right.
I'm looking forward to taking care of my daughter. I've made a lot of changes while I've been in jail.
All right. So here's the thing with that. A motion's going to have to be filed because I said no unsupervised contact. And I'm not going to allow you to have contact with your daughter or have your daughter stay with you. And then the next thing I know, you're bringing some new woman in the house to be her stepmom. I'm not going to allow that. You understand?
Yes, Your Honor.
All right. Good luck to you.
Thank you. Thank you.
All right. Could I have the
In a high-stakes session in Behar County, the court of Judge Stephanie Boyd called the case of the state of Texas versus Justin Gonzalez. Gonzalez stood before the bench in an orange jumpsuit to face a second-degree felony charge of aggravated assault with a deadly weapon. The proceedings centered on a plea bargain agreement that would determine whether Gonzalez would face immediate prison time or a path toward rehabilitation. The atmosphere in the courtroom shifted from procedural to personal as Judge Boyd delved into the roots of the offense, a violent altercation involving a knife and the defendant's own brother. While Gonzalez initially attributed his lack of child custody to instability and the mother of his child, Judge Boyd pushed for transparency, reminding him that the court cannot offer support to those who are not truthful. Under direct questioning, Gonzalez admitted to a history of drug use, identifying his drug of choice and acknowledging that his addiction had played a role in his current legal standing. Despite the gravity of the family violence and deadly weapon findings, Judge Boyd followed the plea agreement, granting Gonzalez 7 years of deferred adjudication. However, this mercy came with a rigid set of boundaries designed to break the cycle of violence. Gonzalez is strictly prohibited from living with his mother or stepfather to prevent further family animosity and must have no contact with his brother. He was ordered to undergo drug and mental health evaluations, enroll in hostility aggression courses, and complete 150 hours of community service. In a final word of caution, the judge emphasized that while his family had stepped up to the plate to raise his daughter, he remained barred from unsupervised contact with her until he could prove his stability. The case serves as a final warning. The path to redemption is open, but the price of failure is 20 years in prison.